welcome to the Putnam County Library Lunch and Learn. Today we are joined by Christine McMenamin, who will be discussing tenants' rights. Take it away, Christine.
Thank you, Spencer. So I am honored to be here today to talk about tenants' rights, specifically around here in Putnam County. So my name is Christine McMenamin. I am the managing attorney in the Cookeville office of Legal Aid Society of Middle Tennessee and the Cumberlands, and we have our office here in Cookeville. What we will cover today is an overview of Legal Aid Society, Tennessee rental law basics, your lease, the most important document. We'll go over that. We'll go over tenant responsibilities, landlord responsibilities, repairs and maintenance issues, eviction process in Tennessee, subsidized housing protections, practical tips, and when to seek help. And at the end, I'll leave time for questions and answers if anybody has any questions. So Legal Aid Society is a private nonprofit law firm, and we provide education and representation in civil matters for low-income individuals, families, and seniors who normally could not afford legal services. Our mission is to advance, defend, and enforce legal rights of low-income and vulnerable people in order to secure for them the basic necessities of life. So I do want to say, although primarily we do represent low-income people, there are some grants that we receive to help people regardless of their income. Most importantly, those are for seniors age 60 and over. We do not take into account income for helping seniors. And also those who are domestic violence survivors. We don't have any income limits to represent those people. Also, we do have some grants in our consumer law space to be able to help people regardless of their income. So my advice is usually to call our office and ask, and we can go over that information to see if we can help you. And our mission, again, is to enforce, advance, and defend the legal rights of low-income and vulnerable populations. Legal Aid has, we cover 48 counties in Middle Tennessee and the Upper Cumberland, and we have 8 offices across the state. So the areas of practice that we do cover are bankruptcy, consumer protection, education, elder law, employment, family law and domestic violence, health law, housing, some immigration law, juvenile law, mortgage foreclosures, public benefits, and tax disputes. And the counties we serve out of our Cookeville office are Clay, Cumberland, DeKalb, Fentress, Jackson, Overton, Pickett, Putnam, Van Buren, and White counties. Okay, well, I am a housing attorney, so today we are talking about housing. And in our housing practice, we can't cover everything, unfortunately, because we don't have enough people to cover everything in all 10 counties that we serve in the Cookeville office. So our priorities in our housing department are to help keep people in their homes and make sure they're being treated fairly when they are in their homes. So primarily what we focus on is eviction defense, both for private and public tenants, depending on the situation. Admissions and denials to public housing if someone's trying to get into public housing. Reasonable accommodations for disabilities, and fair housing or housing discrimination. Now, this is not a list that says we only do these types of things. So again, you're gonna hear this a lot from me today. Please just call our office and ask if we can assist you with your specific problem. I can't go over all the different problems that tenants have in their tenancies in this presentation, but those are the most common ones that we serve, but please don't be afraid to ask us. Just a quick disclaimer, we do not help in criminal defense, we do not help in personal injury cases, and we do not help in real estate closings, just in case those are things that we definitely don't do. And the general disclaimer is the information provided in this presentation cannot take the place of legal advice, and each case is different and needs individual attention. So again, please call our office about your specific case. Okay, so Tennessee rental law basics. We're going to go over URALTA, what URALTA is and what that means. For for tenants here in the Upper Cumberland. The lease controls most of the time, so we will go over that. And what do courts usually look for when there is a dispute? So the Uniform Residential Landlord and Tenant Act is URALTA, and this is a law that first became effective in July 1975. Since then, it's been restricted to only apply to counties who had a population over 75,000 people as of the 2010 census. So this is something that confuses a lot of tenants, so I want to spend some time here. When you look up what does a tenant do for XYZ in Tennessee, a lot of times the internet will not make this distinction between what counties are covered by this law and what counties are not covered by this law. So even though now in 2026, Putnam County has a population over 75,000, the law says it's only based on the 2010 census. In 2010, Putnam County had less than 75,000 people. Therefore, Putnam County is not covered by this law. And in fact, all 10 counties that I talked about before that the Cookeville office covers, none of the counties are covered by this law, which we call URALTA. So that is a very common mistake, and if you're not an attorney, you may not know that. So I want to make sure everyone understands that any tenant in any of the Upper Cumberland counties cannot rely on this law for their tenant protections. So if you are Googling or using ChatGPT or anything like that, please be aware that that may not be accurate for your specific circumstance. So what does cover you? So in Putnam County and all of Upper Cumberland, the courts must abide by common law, which means that they abide by what the courts have said in the past in these types of cases. And they cannot use the statute, which is URALTA, when deciding, especially eviction cases, but really any of these landlord-tenant cases where this would apply. So, excuse me, so now that we know that URALTA does not apply, we'll go into some more of the tenant protections and basics. So, notice requirements. In most Tennessee counties that do not follow URALTA, such as Upper Cumberland, eviction notices depend on the situation. So because we're not using a statute and we're using common law, we're using cases, I can't be very specific because it depends on the situation. And I know that I'm going to say that a lot, but unfortunately that is true. So generally, if your rent is not paid or there's lease violations or the landlord thinks you violated your lease or is saying that you did, usually that involves needing a 14-day notice to fix the problem before the eviction can be filed. We'll talk about why I say usually in a second. Also, ending a month-to-month tenancy. If you do not have a lease and you're just paying your rent monthly and staying there monthly, then usually that does require a 30-day notice from the landlord to stop that tenancy. If a landlord wants you to move, simply because they want you to move, it doesn't have anything to do with the rent, then generally if you don't have a lease, you would need 30 days notice. Now, if there are serious safety threats, that may allow a landlord to move forward with a much shorter notice, typically 3 days. And again, this would be this would depend on the facts, very case specific. So it would depend on what the landlord is alleging and what actually happened as to whether 3 days notice is sufficient or not. And usually you wouldn't know that until you get before a judge. So it definitely depends on the facts. And so since every case is different, tenants really should seek legal advice if they receive an eviction notice as soon as possible, so that the attorney can look over your specific facts and figure out exactly which notice applies. So, again, it is important to remember that notice rules vary depending on your lease, local court practices, which county you are in, and the reason for eviction. So some landlords may file an eviction without giving advance written notice. and then the courts would ultimately decide whether the notice was legally sufficient. So really there's no step. If you get a court notice, then we'll talk about this, but you have to go to court and talk to the judge about why you may think that's insufficient. So if you get any sort of notice like this, please contact either legal aid or an attorney to go over everything so that you can find out if it was done correctly or not. So your lease, most important document when it comes to landlord-tenant issues. So if you do have a written lease with your landlord, make sure you keep your copy of that lease very protected. Make sure you have a copy of it. If you don't currently have a copy, you should ask your landlord for a copy so that you have it now. Hopefully you won't have any issues, but the time to ask the landlord for a copy of your lease is not usually when you're in the middle of a dispute. So make sure you have a copy, and if you don't have a copy of your lease that you signed, get that now and make sure you have that. So if your lease says something different than, for instance, what I just talked about, the notice requirements, the lease is going to control, because the lease is the contract that you and your landlord have entered into and signed and agreed upon about what rules over your tenancy. So if your lease says, for instance, that if you get behind in rent, they are only going to give you a 5-day notice, that may be okay. And I say may because, again, it depends on the circumstances in your case. It depends what kind of tenancy you have and a lot of different factors. But usually the court is going to go by what your lease says. So it's very important that you know what your lease says and that you have a copy of that. So, tenant responsibilities. So the most important things a tenant can do when it comes to living in an apartment or a rental is, number one, and this is number one for a reason, communicate with your landlord. Most disputes, not all, but most disputes can be resolved just by communication. And a lot of times, the earlier the better, depending on what the situation is, especially when it does come to situations that maybe are affecting your ability to pay rent, such as losing your job, becoming disabled, having to have surgery, things like that. Sometimes tenants don't want to talk to their landlord about that because they're afraid, of course, of being evicted. However, sometimes talking to your landlord ahead of time will resolve that issue. If a landlord knows that this is a situation, but they know that you will be able to pay the rent going forward, it's just a temporary situation, sometimes they'll say, I'll give you an extension, or get it paid by the end of the month, or something. So really the communication is really important, because once the landlord does file a detainer or an eviction, sometimes those opportunities are no longer there. So my advice definitely to everyone is to talk to your landlord, especially if there's some problems going on. And we'll talk about some other problems such as repairs that are needed in a few minutes. In addition, pay rent on time, keep your receipts. So a lot of issues stem from tenants not being able to pay their rent on time. So when able, make sure that's an important priority, to make sure your rent is on time per your lease. Make sure you know the deadline for your rent. Most of the times it's the first of the month, but not always. So make sure you understand when your rent is due. And keep all of your receipts, whether that's an actual printed receipt that the landlord gives you, whether that's screenshots because you've paid electronically, or if you've deposited money into a landlord's bank account, make sure you keep the bank receipt. Whatever type of way that you pay your rent, make sure you have proof in writing of paying that rent. Just your bank account statements usually are not enough, so make sure you have proof. And I suggest you keep those receipts for the whole time that you live in that apartment, because you never know when they may be needed, unfortunately. I have a lot of tenants who trust their landlord. Their landlord's a good person, and they say, I trust them, they understand that I paid the rent, they know they're never gonna do anything. And that may be true. The problem is that depending on how long you stay in your apartment, that person who is your landlord may not be your landlord for the whole time that you stay there. Unfortunately, people pass away, people move away, people sell their properties. There's a lot of different reasons why the landlord that you trust may not be your landlord 2 years from now, and that person doesn't know you, or you don't trust that person, and if you don't have your receipts, there could be some issues. So just keep all of your receipts, throw them in a file or a folder or a drawer so that you have everything in case you need it. Another more important thing that a tenant must do is avoid property damage, of course. So anybody would say that, of course I shouldn't damage the property, but this also includes people that live with you, and also people that come into your apartment, so guests or visitors. Now, one important thing to know about this is that if you are experiencing domestic violence, you may be protected against any damage to the property done because of the domestic violence by the abuser. So that's a specific circumstance where you'd want to contact legal aid or an attorney that's not legal aid, any attorney, to talk about that, because that could be an issue where you may have some extra protections because of that circumstance. Keep the unit reasonably clean. Reasonably clean means something different to everyone, but generally a court is going to say, look at pictures if a landlord is saying you did not keep it reasonably clean. So it's really going to be up to the judge whether that is reasonable, but try and do your best to keep it reasonably clean, because that could be a circumstance where a landlord says that you violated your lease or that they try and evict you if you don't do that. And then it also comes up, of course, when you move out. Do not disturb neighbors. So all tenants have a right to quietly enjoy their apartment or their rental. And if neighbors are disturbing you, or if you are disturbing neighbors, that could be a problem. So that could mean loud music, that could mean a lot of different things. Yelling, screaming. Again, if there's domestic violence present, that is different. There may be extra protections, but otherwise, do your best to not disturb neighbors, and not just you, but anybody in your household, anybody coming to your house, visitors, guests, anything like that. And allow reasonable access for repairs. So this comes up a lot if a tenant is requesting repairs, but then can't be available to let people in to fix what needs to be fixed. So you do need to allow reasonable access. Now, reasonable access usually means you have to have some notice unless it's an emergency. So if the pipe bursts and water is coming all over your apartment and your apartment's flooding, that is an emergency. You need to let somebody in as soon as possible to fix it without any prior notice. However, if there's a light fixture that needs tacked up to the wall, or some other repair, plumbing repair, something like that, that's not exactly an emergency, you should get prior notice depending on your lease, and you need to allow the access for those repairs. If you keep saying, I can't do it this day, I can't do it that day, I need to reschedule, that may become a problem. Okay, so landlord responsibilities. What does the landlord need to do? So the landlord's responsibilities under the law, again, we're talking in the Upper Cumberland, not under Uralta, but just based on common law. They do have to provide habitable housing. So for instance, habitable housing means something, all very important essential services are in the home and they're renting that out. So for instance, if they were trying to rent a property out without a bathroom, there's no bathroom in the property at all, and they're trying to rent that out, somebody may argue that's not habitable. You can't collect rent on a place that doesn't have a bathroom, for instance. If there's no electricity at all, there's no way to get electricity in the unit, that again may be uninhabitable. So that is definitely up for argument. So I can't go through a clean list of what's habitable, what isn't. It's going to depend on your circumstances. So landlords also must maintain structural safety. So they need to provide something that is structurally sound. If it is not, that could be a very big problem. They must follow the lease terms. So both tenant and the landlord must follow the lease terms. And they must use a court process for eviction. So in Tennessee, all of Tennessee, a landlord's not allowed to use what's called self-help to evict someone, which means they can't just decide that they want to evict you and go change the locks that day. They do have to go through a process. Even in non-Uralta counties, such as the Upper Cumberland, in all the counties in the Upper Cumberland, you still need to go through a court process to evict someone. And so a landlord must go through that process if that's what they're trying to do. Okay, so now we're going to talk about repairs and maintenance. So what do you do if repairs are needed in your home? So first step should always be that you notify your landlord of what needs to be fixed. So you should do this as soon as possible, and you should do it in writing if possible, because later on, if you need to prove that you did this, you won't be able to if it's all verbal, let's say on the telephone. Now, can you call the landlord and tell them? Yes, of course. But then follow up with a text or an email or a letter, whatever is easiest for you to do, but you should do it in writing. You should also document the problem, what needs to be fixed. So keep all copies of messages that you've done to the landlord, all your repair requests, take photos or videos of the condition. Usually I advise people to take both because sometimes you don't need a really long video to show the problem. Sometimes a few pictures is fine for a court to look at. And you should write down the dates that you're communicating with the landlord about these issues. Hopefully your dates will be on your notices or your things in writing that you've done to tell the landlord about the problem, but just in case, write down all the dates that you contact the landlord or that you discuss this with the landlord. And then third, you should allow reasonable access for the repairs as we talked about before. So if you are asking for something to be fixed, you need to let them in to fix it. And very, very important, this is something that's one of the most commonly misunderstood parts of housing law, is that in most non-Uralta counties, tenants generally cannot withhold the rent because repairs are not made. As more and more people are moving to Tennessee from out of state, other states have different laws, and sometimes people are used to laws that protect them to withhold their rent if, let's say, they can't use their water for a week. Unfortunately, here in Tennessee, unfortunately for tenants, that is not a law here, so they cannot do that. So you need to know that you cannot withhold your rent just because there's a repair that needs to be made. If you have any questions about this, please contact an attorney to talk about that. Because the problem is that if you withhold the rent and you're not allowed to, you could be evicted. And so you don't want to unintentionally cause yourself to be evicted because you thought that you were protected by withholding your rent. Okay, so what I've talked about so far really applies to private tenants, meaning tenants that don't receive a subsidy or don't live in government housing. I just wanted to talk quickly about subsidized housing, because if you do live in subsidized housing, you do have some different rules and regulations and laws that protect you in certain situations. So you may be a subsidized tenant if you receive a housing choice voucher, which most people know is Section 8. So if you get a voucher where you can take that and you can pick where you're going to live and use it wherever you pick, that's a housing choice voucher, and that means that you do have subsidized housing and you have certain rights. In addition, if your rent is based upon your income, so let's say you don't have a voucher, but you know that your rent is based upon how much income you have, that's a good sign to say that you probably are in subsidized housing. If you regularly need to report to the landlord your income or any changes in your income, or recertify every year what your income is, that's also usually a sign that you're in subsidized housing. Also, if you live in public housing or another government assisted property, if you know that you live in public housing or you know that you live in a subsidized property, then you're a subsidized tenant. This is really important because eviction rules and notice requirements are often different for subsidized tenants, and so it's very important that you talk to an attorney as soon as possible if there's any problem whatsoever with your tenancy, so that the attorney can go over what particular rules or laws apply. Many programs require additional notice or longer time periods before eviction. Now, it does depend on which program covers you, and it's very difficult usually for tenants to figure that out. So again, please contact an attorney. Legal aid can help with this, and we can find out what laws apply and advise you about what your rights are and what steps you need to take. And the required notice does depend on the type of housing subsidy. So just because you're in subsidized housing doesn't necessarily mean you have X amount of time. So there is no one law that covers every single type of subsidized housing, no matter what, let's say for notice. It does depend on the subsidy. So that's where speaking to an attorney would be very helpful. And yeah, so it's best to contact an attorney or specifically legal aid when you receive that notice from your landlord. Don't wait until you get court papers, things like that. Try and contact us as soon as you can. Okay, so now we're going to talk about the eviction process in 9 Rialto counties in Tennessee. So the process is that the landlord would file and serve a detainer summons to the tenant, letting them know when and where to appear in court. This usually happens in general sessions court, but it doesn't have to. It also could be filed in circuit court, but that is pretty uncommon for many reasons. But it would tell you that the notice would tell you, and I'm going to show you a copy of that so you know what it looks like. It would tell you need to be at this court on this day at this time. That's the most important information on that notice that you need to pay attention to. And this is the best time, if you haven't already contacted legal aid about the situation with your landlord, the best time as soon as you get that notice to contact us to see if we can provide counsel and advice, or if we can represent in court. And Putnam County General Sessions docket call for detainers are usually heard on Tuesdays. So generally in Putnam County, if you receive one of these, the first appearance will be usually set for a Tuesday. So I'm not sure if you can, hopefully you can see that good, but this is the standard form in the court, and this is usually what a landlord will file. And it says right here, you can't really see where I'm pointing, but up here on the top left, it says detainer summons. And that is the section on the top left under where it says State of Tennessee. That's going to be telling you which court to go to and when. So that's what you have to look at. Look at all of it, but that's really the very important part that you need to know. And then this is the back of the form. The back of the form isn't going to be as important for you when you initially get this paperwork, but it is important for an attorney that's advising you. Okay. So any party, either the landlord or the tenant, can request one continuance from the court in order to seek legal representation. Generally in Putnam County, the judge will reset the case for the following week. So it doesn't give you a lot of time, but it could give you some time to find an attorney. So if you contact legal aid and we say, unfortunately, we don't have any attorneys available, you can go to court and ask the judge, can I please have a continuance so that I can try and find an attorney? And generally, you will receive that if it's the first time you're in court for that case. Now, if you forget to do that on the first time, you're most likely not going to be able to ask for that later on. And also you're not going to be usually allowed to ask for that more than once in the case. So if you say, can I have more time? And the judge says, yes, come back next Tuesday. And then you come back next Tuesday and you say, can I have more time? Usually the answer is going to be no, unless you have a very good reason. But usually the answer is going to be no. So either on the first appearance, if no continuance is requested, or at some later date when you do come back to court, the parties will either come up with an agreement or the court will have a hearing. And the court will either have the hearing that day, so you always have to be prepared to have a hearing that day, or it might be set for another day. It depends on the day, depends on how long the case might take, depends on a lot of different factors. And if you have the hearing and the judge grants the detainer, then the tenant will have at the very least 10 days to move. That is due to the law, the common law. So if you lose when you go to court for an eviction, you will, have 10 days to move. The judge could grant more. I will say it's fairly uncommon, so I wouldn't go in expecting that you're going to get more time, but you should go in expecting that you'll get 10 days. And if the tenant does not move out of the apartment within those 10 days, or if the tenant does not appeal the decision, and appeals, usually you would need an attorney to probably do that for many reasons, then the landlord can obtain what's called a writ of possession and ask the sheriff's office to remove the tenant and their belongings from the premises. A writ of possession is basically the permission from the court to give to law enforcement to actually do the eviction. So the judge can grant the eviction, but then the landlord would need what's called the writ of possession, which is actually the final permission saying, yes, sheriff's office, or yes, law enforcement, you can remove this person if they're still there. And so after eviction, unfortunately, there's not a lot of resources available for tenants that are displaced after an eviction. We would love to gather additional resources we may not know about, so if anybody is watching this training and has those resources, please contact me. We're trying to gather as many as we can for all 10 counties that we cover. Some resources that we do know about is our HART, Homeless Advocacy for Rural Tennessee, UCRA or UCHRA, Upper Cumberland Human Resource Agency, and the United Church of Cookeville in Cookeville. Okay, so practical tenant tips. We talked about this a little bit before, but tell your landlord early if there is a problem. The communication really is key. I can't stress that enough, because a lot of times, a lot of time and a lot of effort could be saved if the tenant would have talked to the landlord in the beginning. Keep proof of all of your rent payments. Again, very, very important for the whole time that you live there. Regardless of how much you trust your landlord or you know the landlord's a good person, you never know the circumstances a year, 2 years, 3 years from now, if that person is still gonna be your landlord. So keep all of your receipts. Report any income changes right away. This isn't just for subsidized tenants. This is also for private tenants, because if you lose your job, if your hours are severely cut from work, if you had to go into the hospital for a week and now you're not going to get a paycheck, if you communicate those things with your landlord, there's at least a possibility that something could be worked out. If you don't communicate those things, there's no possibility, because the landlord doesn't know what's going on. So it's always best to communicate that with your landlord, so at least you can have the chance to work it out. And always go to court if you get a court date. I can't stress this enough. As an attorney, always go to court. If you are like, I'm moving anyways, I know I'm going to lose, or whatever, it's just always best that you go to court, because if you are not at court, then you absolutely would lose, most likely, and things are done without you knowing what happened, as far as the order, possible money judgment against you for any rent the landlord says you owe. You don't have any chance to be heard if you are not there. So our advice is usually go to court if you do get a court date, even if you don't have an attorney. Okay, so if you are a subsidized tenant, it's best to contact us as early as possible. If you have questions, if you know there's a problem, even if you haven't gotten a notice yet from your landlord, or if you got an initial notice but you haven't had court, please just contact us as soon as you can. If you receive court papers, that's definitely a good time to contact us as soon as you can. I will say we have one attorney who, I would say it's a very small percentage of time that he can devote to housing problems. And myself as the managing attorney, I also can't devote 100% of my time to housing. So we don't have a lot of people handling housing issues for all 10 counties. So we are understaffed, but we do the best we can and help as many people as we can based on our funding. So I know it can be frustrating if you call and we say that we don't have anybody available, but please keep calling and keep, week to week, it depends on our availability. Please continue to call us if you can't get through the first time. If you have unsafe housing conditions and you need advice about what to do, because that can be very tricky, please contact us. If your landlord threatens to lock you out of your apartment, which unfortunately happens a lot, please contact us. A landlord, again, cannot lock you out of your apartment without going through the courts. So that is something that you should contact us about, so that hopefully we can give you advice and possibly help you in that way. And if you have any questions or need advice about any sort of landlord-tenant issue, you can contact us. We can't promise that we can help in every single case, but we will try, and we can absolutely at least tell you if we can't help. We may have some resources to send you, but it's better to know if we can help by contacting us than just assuming that we can't. And again, there are certain grants we have where we can help people regardless of your income. So don't assume that we can't help because you make too much money. If you are 60 and over, we don't have to worry about income limits. If you are a domestic violence survivor that has to do with this case or your case, we don't usually have to worry about income limits. There's a few other scenarios, so please let us know. And we cannot assist with looking for a new apartment. Unfortunately, we just don't have the staff to do that. And so if the only reason you would call is to have us try and help you find a new apartment, unfortunately, we can't help with that. We don't have any private lists or anything like that, and we don't have a way to get you into a new apartment. So we can't help with that, but general legal questions about your tenancy, we can help with. And I provided my contact information. Again, I am the managing attorney at Legal Aid in Cookeville. Our website is www.las.org, and that's a good way to find our contact information. And there's a lot of resources on our website so that you can look and maybe get some information even if you're not able to speak to an attorney. So, thank you.
Thanks, Christine.